So I got a question about that. So if it is ambiguous, Brad and Steve, someone has a mold claim and it's hard to determine what's going on. How do you settle that issue? I mean, is it the attorneys getting down and dirty and trying to figure it out? I mean, or does it go to the courts, the trial? I mean, how do you make sure that it's done right?
Steve, I'll let you start with that one.
Sure. So, and Brad raised a good point earlier that typically when there's a tenant lawsuit, the plaintiff, which would be the tenant in that case, is the party that has the burden to prove the liability and the damages. The problem is that one, you have strikes against you. One, you're a landlord. Mm-hmm. And, just with the tenant-friendly laws, there's going to be a strike against you as being a landlord. Two, juries, especially where I practice in the Bay Area, San Francisco, Berkeley, Oakland, those jurisdictions, the vast majority, the majority of the jury is going to be a pool of tenants. Mm-hmm. The third strike is, there's a negative connotation with mold. Everyone hears the word mold and they get shivers. And so whenever there is the existence of mold, and typically the tenant will bring in some, photos showing how pervasive the mold is, that doesn't look good. So to answer your question, how do you resolve the liability or the proving of how the mold impacted that person directly? Well, in the lawsuit, there's a portion of the lawsuit, the pre-litigation, called discovery, where both parties get to ask questions, request documents, ask for proof. So all the documentation and evidence is submitted to the parties before the trial. And then it would come down to the judge or the jury to listen to all the facts and contributing factors. And when a tenant is claiming, injuries because of mold, health issues, that opens up that person's potential medical history or medical past, such that you can see, well, maybe there's some other contributing factor that caused this person's illness as opposed to mold. But at the end of the day, it would come up to just the trier of fact, which would be the judge or the jury, to decide whether or not the mold was the cause and effect of the person's illness. Being said, the vast majority of these cases, before it gets to that point, because parties know the potential risks, the landlord, the potential liability risk, and the tenant, maybe they do have some other health factors that would diminish the possibility of them prevailing. So typically it ends up settling with the landlord writing some check, and they're not small checks. Mm-hmm. Typically, in what I'm experienced up here in the Bay Area, to the tenant to resolve the case.
Yeah, and I'll totally echo everything that Steve just said, but I'll also make cite a quote that Steve said. He said that litigation is costly, right? And that just plays into what he just said about the settlements, because as things kind of progress, maybe the landlords are able to justify or to prove that it wasn't the mold that caused it, was something else. At what expense is that going to be? And so, but he also said that the landlords may wind up cutting a check to settle out, and maybe a bit of a larger check than what they wanted to. And I think this is a bit more where we kind of come into play for our clients, because asset protection really is designed to put our clients, in this case, and the landlords in this particular conversations, into a position to enter into a fast and favorable settlement. In other words, a more favorable settlement than they would have been in without the asset protection in place. Because when you get attacked, you really do feel like you're on the defensive. And Steve had mentioned already, and I will definitely echo with that. It is a tenant-friendly environment, and especially demographically from where he's located, it's also a jury pool tenant-friendly environment. Ultimately, the landlord wants to be in a position to not, if they have to write a check, to write the smallest check possible. So remember, you got two different sides of this transaction. So not only do you have a cost to the landlord in defending this, you also have a cost to the plaintiff in pursuing this. In most of these cases, Steve, correct me if I'm wrong, I'm assuming that these are being done on a contingency fee basis. Is that correct?
Generally, yes. Yeah, I'd say across the board, yes.
Okay, so now you have plaintiffs' attorneys who are basically funding these plaintiffs' litigation in the hopes of receiving 30, 40% contingency fee. And so when they themselves, through the discovery process, realize that in order for them to, even if they win the litigation, if they find that they're going to have a whole nother battle to try to collect on that judgment, then they themselves realize that they need to get out of this as quickly as possible. And again, this is where some of the asset protection kind of comes into play. When they realize that when they win the lawsuit and they have to work all the more harder to collect on that judgment, they also may be encouraging their clients to go ahead and settle out just because of the challenges that they may deal with in the collections process. And so that's where, again, where the asset protection really shines. It gets you in a position to negotiate a faster and more favorable settlement with the plaintiff than you would have been without it. And again, it's nothing to do about whether or not you get sued. We can't control that. What we're trying to control is we're trying to, if you get sued, to how quickly can you get out of this thing, and how little can we get you out of it for. And that's kind of where we play in. So again, I think it's a little bit of both. I think it's the totality of the circumstances to what Steve said as far as litigation is expensive, but yet we want to kind of encourage that through some of the structuring that we put in place as well.